So we've talked about plea deals and what it looks like if you have a chance to plea out, or if you are in a situation where, a plea deal makes sense and we don't want to risk a jury trial.
Mm-hmm.
But there are many circumstances where the plea deal is not any good, and it's not fair.
Mm-hmm.
And justice can only be served through actually putting the case in front of a jury. So can you walk me through what that looks like?
Yes. So there are a whole lot of steps in getting the case case started in front of a jury to actually getting that verdict. The first part that we normally do is what we call pretrial motions, which is a little bit different than like the months leading up to a trial. These are called motions in limine. And so these are the initial motions where we go to the judge with the evidence, both sides, the state and the defense, and we talk about what is or is not admissible, or we have agreements, we negotiate agreements about things we can present or cannot present, or if we don't agree on it, the judge will rule on it.
Okay. In law school, we learn all sorts of old Latin terms, and I have no idea what in limine actually means, but it always sounded to me like limine.
Mm-hmm.
And that's how I think of motions in limine, is it limits what gets into trial.
Right.
So for example, if there's some evidence that everybody thinks is questionable, or whether or not it should be something that the jury gets to consider, can file a motion to try to keep that evidence out.
Right. And that resolves the issue ahead of time so that you're not dealing with it in front of the jury or in the heat of the moment. Because, sometimes, or a lot of the time, I want to know whether or not a particular piece of evidence is coming in, because that might change my defense strategy. If a bad piece of evidence is coming in, that's something that I'm going to want to, know ahead of time so that I can get ahead of it. Or if it's staying out, great. That might change how I present the remainder of the case too.
And we've got a lot of our standard motions and things that you learn over the course of practicing law for decades. You get your motions just right, so that you can go and put those in front of the court, and you got a better chance of keeping that bad evidence out that's going to hurt a client. What's next?
So next would be jury selection, which is kind of a misnomer.
How do we pick our jury?
Exactly. So the way that works is everybody's called in for jury duty, and everybody's familiar with, you get that letter in the mail saying report for jury duty to the courthouse, right? Typically people aren't so excited about it. But they will all report there. The judge will bring up a group of potential jurors into the courtroom, and we will voir dire them. That just means asking them a whole bunch of questions.
Lawyers almost never get to be on juries, because the lawyers that are there picking the juries say, oh, that's a lawyer. That's somebody I probably don't want teaching the rest of the jurors what's actually going on.
And typically, depending on what area you practice, as a defense attorney, if there's another defense attorney on that jury, I'm going to want him on that jury. But the prosecutor's not. Yeah. And so they're going to get kicked off by one side or the other. Like that, it's
We're
almost
strike them.
Yep, exactly.
That juror's gone.
Striking, yes. So that is the misnomer of jury selection, is that you're picking people, and when in truth you are eliminating people. And so that's people, it's not based just on who you like or who you don't like. It's based on biases or personal experiences that those people have that might make them not an appropriate person to decide that case.
So is it like baseball? Do you get 3 strikes? How many strikes do you get?
So each side gets 9, what are called peremptory strikes, and those are we can just decide who we want to strike. There's another type of strike called a strike for cause, and those, they don't count against your peremptory strikes. Those are strikes for people who just can't hear the evidence, who just cannot be fair to either side or one side or the other. That most often comes up, or a very easy example is if we're trying a case involving, a rape or child molestation, and somebody has had that experience in their life, and they're just like, I just can't do it. I can't hear it. I can't listen to it. Not going to do it. That person would be struck for cause, because that's not going to provide the defense a fair trial. And really similarly on the other side, they're just not going to be able to hear the case.
Yeah, and it's not going to traumatize that juror.
Right.
Yeah. And so we get as many strikes as we want on the strikes for cause.
Right.
So talking about strikes, so you choose who's going to be on your jury, you get done with all your strikes. What happens then?
We have what are called opening statements. And that is a presentation to the jury of what the evidence is going to be. It's not an argument. We can't argue in opening statements, but it's really just sort of describing what the jury is going to see or hear.
But it can be persuasive.
always can be persuasive in terms of what you're going to focus on, but you're really just, it is descriptive. The evidence will show is sort of how they introduce this topic of how you write an opening in law school. But that's the idea that you keep in your head. The evidence is going to show you this.
Mm-hmm.
You're going to hear from this person. They're going to tell you this. And so it's orienting the jury to the case and what you want them to focus on. So, in opening arguments or opening statements, I am either getting ahead of bad facts to try to take the wind away from the state, or I'm really trying to emphasize, I need pay attention to this person and what they're going to tell you. Pay attention to this thing that you're going to hear. And, we'll talk about it in closing. I'll tell you why that matters.
So it's less persuasive than it is tactical.
Yes.
Okay, interesting.
Mm-hmm.
What happens next?
So after we've made opening statements, then the state goes first because they have the burden of proving the person's guilt beyond a reasonable doubt. So they do their presentation.
Let me stop you for a minute. What is the actual burden of proof? Because it's not beyond a shadow of a doubt. Right. We hear that a lot,
Mm-hmm.
And it's not beyond any doubt at all.
Right.
What is it? What is the burden of proof?
So it is beyond a reasonable doubt. And there's a lot of discussion about what that actually means. What the judge instructs the jury is that it is exactly what it says. It is the doubt of a fair-minded juror honestly seeking the truth.
So at the end of the day, it's kind of whatever the juror decides.
Right.
It's the doubt in their own mind and their own heart.
Right.
Okay. The jury comes in, they're impaneled. You make your opening statements. What's next?
So that's the state's presentation of their case. So this is what we call our cases in chief, and the state goes first. So they call their witnesses, they present their evidence. This is where you see the direct and cross examinations. And once they present all of the witnesses and evidence that they do, that's where you see things exactly like you see in movies and on TV. That's one that's accurate, where the state will rest. And that means they're done with presenting their case.
Cross-examination was always the most fun for me.
Oh, I love crossing. Yeah. It's really the bread and butter of being a defense attorney is cross-examination.
Yeah, where were you on the night of the 14th?
Right, exactly.
Okay. So you get a chance to take those witnesses who are maybe saying some things about our clients that are either untrue or unfair, and present them with contrary evidence and show that maybe they've got a bias or maybe they're lying.
Yep.
And that's where reasonable doubt comes from.
Yep. Okay. So once the state is done with their case, occasionally there are some motions or other things that might happen before the defense starts. For one example, a directed verdict. And that's where I would tell the judge that, hey, they did not prove one element of this crime.
Wait, we can win without even going to a jury?
You can.
Oh, nice.
Yeah, it's uncommon. It's really hard because to win a directed verdict, you are arguing that the state failed to produce any evidence, contradicted evidence, that you're going to lose that motion. Any evidence on that charge.
Sure. It's like when you've got a couple different elements of a crime, they have to show X, Y, and Z in order for a conviction to apply. And they show X and Y, but there's absolutely no evidence of Z.
Exactly.
Directed verdict.
Correct. And that is the judge literally directing the verdict is not guilty on that charge.
Nice.
Mm-hmm.
Have you ever gotten a directed verdict?
Yes.
Tell me about it.
Sometimes. One of the most fun directed verdict arguments I ever made was a case where it was a drug charge. And there are a lot of rules. Drug charges are surprisingly complicated. They are unexpectedly complicated when you get into a jury situation. So everybody knows that the state, they collect the drugs, they test the drugs at the GBI. But in this particular case, the drug was Valium, which is the brand, of course.
Okay.
But the substance that is actually illegal, that's on the schedule of drugs, is always the generic or the chemical compound. And the state only put into evidence the brand, which is not enough to sustain a verdict.
Oh.
And so,
got him on a technicality.
Yes.
Okay.
That is one way where you can win on technicalities. And so I argued that they didn't present any evidence that the actual illegal substance, that drug, was what my client was alleged to have had. And we won that.
That's awesome. So there are times when the lawyer really understanding the nature of what you're charged with, including the nature of drugs, if that's involved, can be the difference between a jury deciding you go to jail and you getting a not guilty verdict without even the jury getting to make a decision.
Right.
Okay.
Yeah, very much. Then another fun one on directed verdicts, because I love them, and especially in drug cases. There was a change on the schedule. So there's literally a statute that lists out all of the illegal substances.
The schedules.
Yes, the schedules of drugs. And they changed it recently where any sort of any like benzodiazepine, anything, used to be individually listed. And they changed that so that it was the chemical compounds, not the actual names of the substances. And I made that argument. The state didn't realize that had changed. And so they got in evidence that it was the particular substance, but not that it was the compound.
So you knew more about the schedule than the state that wrote the schedule.
Yep.
That's hilarious.
Yes, it was.
Okay.
That was a fun one. And so it was actually the GBI testing identified the substance by the substance name, but not by the chemical compound. And so now anytime you see benzos, GBI had to change their policies because of my argument on that.
Nice.
Yeah.
Okay. We're getting law changed. So let's say you don't get directed verdict. Let's say you are in front of a jury and they're going to make the decision. What does that look like?
Well, there's one more step before we even get there. Because then, of course, there's the defense's case in chief, where I get to call rebuttal witnesses or, present any additional evidence that I want to make sure that the jury sees.
That's true. We should probably present a case.
Yeah. And this is also where, our clients can choose to testify in their own defense or not. And that's another decision that I can't make for them. I counsel them on it, but there's a whole lot of reasons as to why someone may or may not testify. More commonly than not, it's not because they have something to hide. There's usually other reasons behind that decision.
Like what?
If they were to testify, then the state would get to cross-examine them. And if they do have something in their criminal history that's going to come out, that might potentially hurt the jury's perception of them. So it's not because they have anything to hide about this, but other evidence might come in if they do testify.
Prior bad acts.
Yes.
Gotcha.
Is one
Character
example.
evidence.
Character evidence, that's another potential risk.
And you open that door and you can't close it again.
Yep. And then it's also just very, very risky because I know juries like to hear from defendants, but it's a very stressful, emotional experience, and a lot of times being on the stand under the pressure like that in an unfamiliar environment where literally your freedom's on the line, a lot of people don't perform
You may
well
not be
under
as
that type
eloquent as you might be otherwise.
Exactly. People
That's
don't perform
fair.
well under pressure, and that could look bad to a jury.
Well, and that's part of your job too, is the difficulty of not only thinking about how to get somebody to not guilty, but also just thinking about your assessment of them as you're going along defending them, saying, how well is this person going to do on the stand? Because, we can do everything right as lawyers, but we can't be on the stand testifying for them.
Right.
And so we have to make an evaluation of every client and say, how strong a witness is this person going to be for themselves?
Mm-hmm. Yeah.
Okay, interesting.
Yeah.
And so you present your case.
Yes.
What's next?
Then once the defense rests, there is a very boring legal process known as our charging conference. And that's where we sit down. It's the state, the defense, and the judge, and we determine what instructions are applicable to this case and will be read to the jury. And those are the instructions that the jury will use to decide the case. And that is a very boring legal process.
So we call these jury charges.
Yes, jury charges.
All right.
And so once we do that before we make closing arguments because we can use those in our closing arguments. And I want to know what instructions the jury is going to hear. So that during that is where we might decide whether or not do we ask for a lesser included offense charge or do we not? And there are a lot of strategic reasons why you may or may not do that. So once you have all those charges, that's when you have the fun of the closing arguments. And that's really, what everybody sees in
That's your Matlock
TVs, movies.
moment.
Yes, exactly.
We'll
the
have to
Matlock
get you a
moment.
seersucker suit. Do you have
Absolutely.
a seersucker suit?
I don't.
We
I
gotta
should
get
get
you one. So you have your Matlock moment. Tell me about your closing. Is there any technique that you use in your closing that you're really proud of that you feel like juries really resonate with?
There's no one size fits all. It's very much going to depend on the jury, the case, what arguments you're actually making. Because if it's a legal type defense where I'm arguing that, something has happened in the legal process, that's going to be a very different presentation than when it's a factual defense where I'm saying this didn't happen. Or in the case of that trial that I referenced earlier where I got that not guilty, where I'm saying, okay, this happened, but it was an accident. We're not arguing that this, somebody didn't get hurt. We're saying that it wasn't a crime.
Yeah, and one of the things that is unique to crimes is that the vast majority of them require intent.
Yes.
Mens rea, as we say in the legal world.
Yep.
The guilty mind. So, being able to sometimes stand up there and say, yeah, something bad happened. Everybody knows that. And we're sorry that it happened, but nobody meant to have it happen.
Right.
Okay.
Yep. And so once we finish closing arguments, jury goes back into the deliberation room. We send the evidence back there with them, and they deliberate, and we sit in the courtroom and wait.
How long is the longest you've ever had to wait for a jury to make a decision?
3 days.
Oof. What's the shortest?
40 minutes.
Okay.
Yes. Yeah.
On the 3 days, was it a guilty or a not guilty?
It was a split verdict on that one, actually.
What does that even mean?
So a split verdict is where they might find a client guilty of some of the charges and not guilty of others. And in that particular case, that was honestly what I was going for.
I was going to say a split verdict may be the best possible outcome.
Sometimes, yes.
If somebody's definitely going to be convicted of something,
Yeah.
then getting the lesser included offense, getting the smaller guilty can be a huge win, right?
Yeah, absolutely.
Okay.
So in that particular case, it was there were 2 charges. It was an aggravated assault and a shoplifting. And the shoplifting there was no defense to that. There was multiple camera angles on video. Like, the shoplifting happened.
Okay.
The issue was, as my client left the store, he was attacked by one of the employees. And because he had shoplifted, he was charged with that aggravated assault for that fight. But my
So he
argument...
got blamed for the fight, even though he's trying to make it off with a candy bar. Somebody attacks him and starts punching him, and so all of a sudden
literally
he's
jumped on him.
yeah.
Yes.
So you're facing some serious additional charges.
Right. An aggravated assault carries 20 years in prison.
Oh, good Lord.
Yeah.
Okay.
So that was literally our only goal with that case, was we needed to beat this aggravated assault charge. And
Right,
so
don't steal candy bars.
right, and then at least pick a fight afterward.
Yeah.
So that was the whole defense there, and we got that split verdict. So he was convicted of the shoplifting, which I didn't even contest. And then that was a strategic move in terms of presentation of the case, and my client was all on board with that decision. Again, I make decisions very collaboratively with clients, and he understood the strategy and what we were going for, and we got what we hoped for.
Well, and that makes sense, because in some situations, even though you get found guilty, you may walk right out because you've had time served, right?
Yeah, right.
What is time served?
So time served is exactly what it says, credit for the time that you have already served. So if you're arrested and you're unable to bond out, that amount of time that you serve in custody will be credited toward any time that you are sentenced to serve at the conclusion of your case.
Okay.
That makes sense.
So let me wrap this all up by asking, how do I get a lawyer like you to take my case? If I'm in a situation where, I need somebody who's more than a public defender, God bless them, they do God's work. But if I need somebody who doesn't have the caseload that a public defender has, handling, 500, 900 cases at a time, somebody who can focus on my case and have a better chance of getting to not guilty, how do I go about hiring you?
You call.
Okay. What if I have financial problems? Like, what are some financial strategies for somebody in my family to be able to put together the money that's required? Because public defender's free, know, and if you qualify for public defender, you may be able to get one. The problem is that, if you got even minor earnings, you may not qualify to get a public defender. So what kind of financial advice can you give to somebody who's looking to hire a private defense lawyer, but isn't swimming in money?
It's a pretty common practice, and it is something that I do to do payment plans on fees. So, often we can break up our fee into multiple payments or things like that. It just sort of depends on your particular circumstances.
Do the people who hire you always pay themselves, or do they usually have other people in their lives who help them?
Family members often step in and help. Usually it is some amount of a group effort.
Okay.
Yeah.
Well, Kait, thank you so much for your time today.